An issue that sometimes comes up with professional liability cases, I should say cases involving those that hold a professional license, is whether a certificate of merit is necessary in order to proceed with that action. Well, there's rules specific to that, but one of the rules of thumb that I always like to look at is whether there's a relationship between the actual person making the claim and the licensed professional that involves that license. And so it's a rule of thumb that I always go to is, what is the relationship? That is the key. So for instance, if you were to have a licensed engineer who's hired by a water department to put in a line, a water line across the property, and that engineer actually puts it on the wrong property, and that property owner files suit against the water department as well as the licensed engineer for placing that line on the wrong property. The question is, would you need a certificate of merit? And going back to that rule of thumb, what is the relationship between those parties? Well, the property owner did not hire that licensed professional and has no direct relationship to them, but for the trespass of putting that line on. So in that particular case, it wouldn't necessarily be a professional liability case that required a certificate of merit, but rather it'd be more of a property issue and a tort by encroaching upon their property and basically trespassing and putting in the line. So there would be a situation involving a licensed professional that doesn't necessarily need a certificate of merit.